Good evening. Thank you. I hope all of you had a good day as well. Good evening. All right. Let's start. We're going to spend some time from Article 23 onwards. Articles 23 and 24 pertain to the right against exploitation, and Articles 23 and 24 primarily deal with the historical circumstances that prevailed in India and are very purposely curated to be a part of the Constitution, taking into context the social circumstances because of which there were an absolute necessity to create very dedicated fundamental rights. Now, Article 23, as we would know it to be, Article 23, as you would know it to be, is called Prohibition of Traffic in Human Beings and Forced Labor. At the outset, let's look at some keywords. Traffic in human beings, which means referring to human trafficking. Begar, which is the second word, begar. This is not the same thing as beggar. And other similar forms of forced labor are prohibited, and other similar forms of forced labor are prohibited. That's the second term. The third term are forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with the law. Shall be an offence punishable in accordance with the law. Now, when we say offence, we of course mean a criminal offence punishable in accordance with the law. This means that firstly, the Constitution does not make any offence, does not give you the details of it. The Constitution basically says that we need to make a law which is going to criminalize all of these three things, which means this right is a non-self-executory right. This is a non-self-executory right, and you would therefore require an additional law giving details of its criminality and the punishments of the same, which is why we've come up with several laws in India, such as the Immoral Trafficking Prevention Act, which criminalizes a certain set of activities. And one of the common forms of human trafficking is prostitution. And through this article, we will be able to understand the legal status of it. So let us spend some time and let's get our basics right and look at whatever the terms are as far as Article 23 is concerned. Okay, so let us start. Article 23, Clause 1 refers to three things. First, human trafficking. Second, begar. And third, forced labor. To understand these three terms, there are three variables that are in play. First, the consent of the worker. The consent of the worker. Second, the compensation or the payment or the wages. And third, the legality of work. The legality of work. On the basis of each of these three variables, would you be able to understand exactly how all of these three would work in a certain context. So let us start. Human trafficking. The biggest identification of human trafficking is that the consent of the person is not there. The person has been forced to work in a certain activity. Second, it does not matter whether the person is going to get wages, fair wages, unfair wages, it does not matter. Wages and human trafficking have nothing to do with each other. People may get paid for it, people may not get paid for it. It does not matter. The primary issue lies with consent. And third, with respect to legality, it can have both forms of work, legal as well as illegal. The most common form of human trafficking, why a lot of people are pushed into this, is because of prostitution, right? Which is why young children and girls and women are often misled or forced into this kind of work. And therefore, this is a legality trademark. With respect to begar, and this is what you must understand, begar is fundamentally different from how human trafficking works. Okay, begar is fundamentally different from how human trafficking works. To understand begar in a larger context, right, let us get this part right. Okay, in begar, what is basically happening is that the wages are not being paid. Okay, the wages are not being paid, so therefore the consent has been compromised. A person would have given consent with a certain amount of wage or a remuneration in mind. The wages are not being paid. Okay, and therefore there is a issue of begar. Now with legality, most cases begar is legal work, right? Most cases begar is legal work. In some cases, a lot of people are forced into prostitution and are often not even paid for it. So theoretically, a case of both kinds of work can also exist. That is also theoretically possible. Okay? Forced labor is the simplest to understand, wherein there is no concept of consent. Consent has been denied. There are wages, and usually this is legal work, but in rare cases it can also be both. Okay, it can also be both. These are the three basic forms that have been mentioned, and prostitution emanates from human trafficking. You have to be very clear with your concepts. You have to be crystally aware of exactly what is supposed to be meant. Okay? Now, please understand this as clearly as we can. Okay? Please understand this as clearly as we can. So when we do talk about uh, uh, prostitution, or we talk about any of these elements, let's get this part right. We have a law called the Immoral Activities Prevention Prohibition Act. The Immoral Activities Prevention Prohibition Act, right? I'll show you what the law looks like so that you understand what is it that we are referring to. Yeah. The Immoral Traffic Prevention Act. This act is because we had signed an international convention, ratified it in fact, and therefore we had to implement certain legal changes in India, and it's called the Immoral Traffic Prevention Act. Now, if I just show the law to you to a little bit of extent so that you understand what it is, uh, this law, this law primarily, sorry, this law primarily covers broad elements of, one second, yeah. This law covers broad elements of prostitution and how prostitution can or cannot exist. Okay? So technically you don't have a law specific to prostitution. What you do have this law which covers prostitution. So I'll give you very clear definitions of it under this law. See, they explain what is called a brothel, they explain what is called a corrective institution, they explain what is called prostitution. Okay, see, for example, it says prostitution means the sexual exploitation or abuse of persons for commercial purpose, and the expression prostitute shall be construed accordingly. Okay, shall be construed accordingly. Now, let's understand this. This immoral activities or immoral in Traffic Prevention Act of the 1950s, this is what it basically explains to you. That prostitution which is commercial in nature, this is illegal. Now let's understand the word prostitution and commercial. Prostitution or sex work historically has always been regarded as one of the oldest professions in the world. For as long as humanity has existed and prospered, sex work has also been an active profession across societies all across the world. Also, because we have lived in largely patriarchal societies where all across the world women of all societies and all backgrounds have been suppressed in some form or another, there has always been issues like these which have existed. Now, this no doubt is a legal issue, but as much as it is a legal issue, it is also an ethical issue, right? The simple meaning of prostitution or sex work is if a person A is providing sexual services to a person B in return for any consideration. It could be money or it could be anything else. This is called prostitution. I'm sure a lot of you would be familiar with what this means. Now, specifically in India, what is the case is that in India, we do not have absolute clarity on the regulation of this work. Okay. So what happens in India is that if a person A is practicing sex work in a private place, so what is meant by private place? In somebody's home, in somebody's Prashant, leave the completion of the syllabus to me. I know how to pace up when I need to pace up, and I know when to slow. By next week, worst case scenario, your syllabus will be done, and Prashant, you don't have to worry about seeing me again. Okay, so don't worry about it. So if a person A is practicing sex work in a private place, this is perfectly legal. If a person A is practicing sex work in a place which is public, like a hotel or a brothel or a designated geographical area, then this is illegal. So basically what we are trying to say here is that brothels are illegal. People who manage commercial prostitution such as pimps, or they're often called dalals, they are also illegal. But individuals who want to do this on their own in their private space, that is perfectly legal. It becomes slightly complicated because in India, most of the people who practice, who work in the area of sex work, unfortunately are victims of human trafficking. And because they are victims of human trafficking, it is very difficult to figure out whether there was genuine consent, or they wanted to work again, or they didn't want to work again, or do they want to work to their fullest capacity or not. This is more than enough as far as Article 23 Clause 1 is concerned. Now, let's look at Article 23 Clause 2. See, Article 23 Clause 2, as we would know it, refers to some very interesting terms that we often don't look at. Okay. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such a service, the state shall not make any discrimination on the grounds only of religion, race, caste, or class. So, religion, race, class, or caste. What it specifically does not mention is gender, and there is a reason behind this. What we are basically talking about it is, now let's understand this, is that the government by law the government by law can make it compulsory for the people of a country to do a specific job because it is in the interest of the people, right? A very common form of this is called military conscription. A very common form of this is called military conscription. And this was the intention behind the Constituent Assembly, to debate and provide for a generic sort of a word in Article 23, Clause 2. Now, when we talk about military conscription, what is it that we understand? What we understand is that people of a specific age group in a country have to compulsorily serve an X number of years in the army of that country. This is how Israel functions. Israel has a policy of compulsory military conscription, where everybody in a specific age group has to compulsorily serve in the Israeli army, or the Israeli military. It does not mean that they have to fight a war. It does not mean that they have to be at the forefront, but they have to work with the army under all circumstances. Some of them who are not physically capable might be working with the Israeli army in the capacity of welfare officers or administrative assistants. That's okay, but you have to work with the army, which is why you will notice, and they get paid for it, no doubt, because at the end of the day you are working. And a lot of times you will see they will travel once they have finished their conscription. They need a break before they get on to things with life. You will see a lot of Israelis travel to India, especially in places like McLeodganj, and they will spend almost a year or sometimes more than that, and relax and recover from their tough tenure in the Israeli army. Which is also one of the reasons why gender was not included as one of the grounds of discrimination. We know only of means RRSS, or any means a combination of RRS, RRCC, but gender is not mentioned. Which means tomorrow, if the government wants to also have a policy of military conscription, it can do so, and it can exclude women in the country from compulsorily working in the army. This again originates from a larger mentality that women are not physically as capable as men, which is why there have been reasons why they have not been given full commissions, they're not given combatant roles, and so on and so forth, right? So this is how it is. This is Article 23. Anything beyond this is absolutely not required as far as the exam is concerned. When in your social issues and your vulnerable sections, you will study women and children, you would certainly be looking at it in a lot more detail and understand the context of it. But from our polity perspective, we don't need anything else. Now when we look at Article 24, again, very simple, very clear, and there are some contradictions here. See, Article 24 refers to the prohibition of employment of children in factories. It says no child, which means this fundamental right, like Article 23, which was also available for citizens and foreigners, is also available for citizens and foreigners. And no child before the or below the age of 14 years shall be employed to or work in any factory or mine which is engaged in any other hazardous employment. So no child below the age of 14 years shall be employed to work in any hazardous employment, basically. Okay, any factory or mine or any other hazardous employment. Now there is a slight bit of a problem with this particular article, And allow me to accentuate this and explain it to you how. See, Article 24 very simply says anybody below the age of 14 years cannot work in a factory or a mine, or any form of dangerous employment. This means anybody who is below 14 years of age can work anywhere which is not dangerous in nature. A person who is below 14 years of age can work anywhere which is not dangerous in nature, right? Can work at an employment which is not dangerous in nature, correct? Now that we understand this, let us apply Article 21A to this. If every child below the age of 14 years can work, if every child below the age of 14 years can work in a occupation which is not dangerous in nature, then in one way it is violating Article 21A, because 21A says every child in the age group of 6 to 14 years must be given free, and the key word is compulsory education. Compulsory education, right? Compulsory education according to a law made by the government or the parliament, and that is how later the Right to Education Act was also formulated. So on one hand you are saying anybody below the age of 14 can work anywhere which is not dangerous in nature, and on the other hand you are saying it is compulsory for 6 to 14-year-olds to go to school. So there is a conflict, and this conflict shall remain the case as always. Okay? Now, let's see how we can resolve this conflict. Article 24 is also not a self-executory right. It's a non-self-executory right. How do we know this? You see, this is being written here. This is not enough to regulate child labor. So that is why we create a special law, a dedicated law, a focused law, wherein we refer to the Prevention of Child Labor Act. So we create a dedicated law like we did for Article 23, which is called Immoral Traffic Prevention Act. Here we create a Prevention of Child Labor Act, because this is a non-self-executory right. So what is it and how do we really go about it? Okay, so first things first. What is the actual age levels, or what is the age criteria for children and working? 0 to 14 years can't work, 6 to 14 years can't work anywhere because of Article 21A, they have to go to school. 14 to 18 can work with parental consent. With parental consent. And 18 onwards, you are an adult. Under the Indian contract law, you are capable to enter into a contract, and therefore you have the freedom to work. These become your primary ages. Now, the Prevention of Child Labor Act has two lists, list 1 and list 2, wherein a list of businesses and occupations have been clearly mentioned wherein children cannot work. Okay, very clearly mentioned. And through Supreme Court guidelines and exceptions have been added wherein there are special provisions which have been made for child artists, wherein their academics should not suffer. Wherever they are working, it must be a safe working environment. It should not be environmentally or any form of danger to their health. Third, they must be given adequate time to prepare for their exams, and they must be given adequate time to study, and they cannot be made to work in long shifts. Okay, so this is how it runs. This is your basic ecosystem. This is the mechanisms of how child labor works in India. A few years ago, several countries in the world had reduced their ages and had invited a lot of criticism from all over the world regarding this. But this is more than enough. I will show you the Prevention of Child Labor Act as well, so that you understand what is it that we are referring to. Okay. Okay, so Child Labor Act. Now, when we look at the provision of Child Labor Act, this is your Child Labor Prohibition and Regulation Act of 1986. Okay, just show you the law. This is the law. Now, in this law, you will see there are certain provisions which are mentioned towards the end, which contain a list of things that can or cannot be done. You don't need to go through the law. You don't need to know the technical details of the law. You just need to know that there is a law like this which helps you solve. Yes? हाँ, इसमें बिल्कुल हो सकता है लूप होल. ठीक है? Understood this? Yes? Okay. So this is largely how it runs. Anything beyond this is particularly not relevant as far as your Article 24 is concerned. Okay. Now we will move to what is often considered very controversial, but from the point of view of the exam, it is often asked in a very limited capacity, and I am only going to cover what is relevant as far as the exam is concerned. Okay. We are going to understand the fundamental freedom to practice religion. Okay. Let's understand the fundamental freedom to practice or religious faith. This is under the title the right to freedom of religion. Okay. So let's spend some time. This has to be done with the highest amount of caution and highest amount of discretion. Okay. Child artists are an exception to this rule. They can work only if those conditions are met. I just explained. Article 25. The freedom of conscience, free profession, practice and propagation of religion. The freedom of conscience, profession, practice and propagation of religion. What do each of these words mean? You sort of done this before, but I'll still tell you. The word freedom of conscience. Conscience in ethics is often defined as a voice of God. So if you look at traditional conventional moral philosophers, they will often define conscience as the voice of God. But it also in our parlance means your absolute decision on whether you want to believe in God or not, and which God do you want to believe in. That's entirely up to you. So conscience is basically the decision of believing in a higher power or faith. Whether you want to have faith or not, whether you want to believe in God or not, if you want to, however you want to, whichever one you want to, is entirely up to you. There is the freedom of conscience. Now, what does the word profession mean? The word profession here does not mean people who are working in religion. No, this comes from the word profess. So, what does the word profess mean? See, most people often get this wrong, and people think that the word profess means people who are working in religious institutions and organizations. That's not what the meaning is. Okay, right? Now, the profess means that you are able to confess, you are able to state clearly that this is my religion, this is what I believe in, and this is what my faith belief ecosystem is. So, this is whether you have faith or not. Profession is affirmation of faith, that yes, I believe in God, or I don't believe in God. I believe in this kind of God, and I believe in this kind of religion, and so on and so forth. Okay. Then you have practice. Now, practice basically is often contested. So, when we say practice, what does this mean? This means any ceremony or any symbols. So, practice here would refer to religious symbolism. It would also refer to certain religious rituals or practices, right? Now, for example, wearing a cross or a skull cap, or wearing a turban, these are all parts of practice. They also correlate with profession, because when you're wearing a skull cap or a turban or a kalawa or a cross or a tabiz, you are basically stating that I am from a specific religion. So, religious symbols and practice and profession are correlated. But another form of practice is basically the ceremonies, or the certain customs or the certain norms, right? Now, see how this works. How this works is, say for example, uh, going to a pilgrimage, or let us say conducting a religious ceremony, or let us say organizing a religious congregation. These are all methods of practice. Okay. This translate into marriage, into property, into adoption, certain provisions for these are things you have to do before you go to a temple or a mosque. These are the people who are permitted, not permitted. So there is a lot. So practice is a very open-ended term. And then you have something called propagation of religion. Now, when we say that you have the freedom of propagation, this does not mean that you have the freedom of forced religious conversion. See, the whole point of religion, which originates from a Latin word called religare, is an organization of people for common good. That's where the word religion comes from. And you would want to spread the word of your religion to other people. And there are several religions who have been accused of coerced conversions or baited conversions. There have been several reports in the newspapers with respect to Ghar Vapsi. That is why there is a need for a national anti-conversion law. There have also been several reports of Christian missionaries who have asked people from lower castes to convert to Christianity, so that they are able to get certain benefits by the local church, some food, some money, some kind of a job. So there have been different forms of propagation which have been reported in the papers. But what is basically prohibited is forced conversion. And any form of forced conversion, it does not have to be a physical force or a threat, but if you're making somebody convert to another religion for whatever reasons, that is not allowed. A person should do that out of their own will. Now let's take that incident. Let us say there is a person who is from an SC community, and we've spoken about this. SCs and STs, the caste ecosystem is largely very Indic in nature, which means Christians and Muslims don't get SC/ST status, they get OBC status, because the origin of SCs and STs is from largely the Hindu mythology. So Hindus, Jains and Buddhists and Sikhs are able to be classified as scheduled castes and scheduled tribes. Okay, so what happens is that a lot of times there is social boycott, social ostracization, there is a lot of social violence, a lot of caste bias. So there are often times where Islamic or Christian missionaries will come to these communities and say that, listen, it is because of your religion that you're in this caste, and therefore why don't you become a Christian or you become a Muslim? We'll give you all the benefits, we'll treat you well enough, because we don't believe in caste or the SC/ST part of it. Now the issue is, legally you can never change your caste. If you are an SC, you will be an SC. You can change your religion, but you can't change your caste. Caste is not legally transferable. You can't change your caste. Okay, uh, it may have an impact on your children or the children after that, but your caste identity as per Indian law remains the same. Now, so when we look at it in the context of religion, so religion then intertwines with, sort of interludes with caste, interludes with social structures, and that is where propagation of religion becomes an issue. Very honestly, in the exam, this is a negligible question, because these are so controversial in nature that you cannot be asked these kind of questions, right? Now, so let's understand this. What is very interesting about Article 25 is that all other fundamental rights start with giving things, start with giving rights, and then give you the reasonable restrictions. That, for example, Article 19, you have the freedom to speech and expression, you have the freedom to association, you have the freedom to move with assembly, move without arms, assemble without arms, to move anywhere in the country, to reside anywhere in the country, to do any kind of work you want to. But it is, and then comes the reasonable restrictions. Article 19 clause 2, that under security of the state, friendly relations, sovereignty, etc., you will not be allowed to. These are the restrictions that will apply, and your rights would therefore be curtailed. But what is very interesting to note about Article 25, and something you should keep in mind, is that with Article 25, it starts with your reasonable restrictions. It starts with your reasonable restrictions. It doesn't explain what kind of rights you would have, this, that, the other. It straight away jumps to the fact that our originating idea is that your right has been restricted. So, subject to public order, morality and health, and the other provisions of this part, all persons are equally entitled to the freedom of conscience and the right to freely profess, practice or propagate any form of religion. Okay, so what does it say? Your reasonable restrictions are: A, public order; B, morality; C, health; and the most important part, the other provisions of this part. What is this part? Part 3. What does this mean? That not only will this right be restricted on public order, morality and health, this right will also be secondary to all other rights of part 3. So this right will be secondary to all other rights of part 3, which means all fundamental rights are not equal. They have equality of enforcement. You can go to the Supreme Court or the High Court and all of that. You have equality of enforcement. I get that part. But all fundamental rights are not equal. All fundamental rights are not equal. wherein Article 25 can be restricted with respect to any other fundamental right. So if Article 25 has to be restricted by Article 14, that is perfectly valid. Article 14 may not be able to be restricted by 25, but 25 can be restricted by Article 14. Clear? So if your right is treating people, if your religion is leading to people being treated unequally before the law, then your religion will be secondary to the equality of law. If your religion is compromising the life and personal liberty of a person, then your religion will have to take a step back, and life and personal liberty is an adequate, reasonable restriction for that part. Okay, so for that incident, that's a very interesting point. Which this is something that most books miss. This is something that most notes and a lot of these guide books miss. But this is something you should know, right? Article 25 can be restricted by other fundamental rights as well. Now, subject to this, and all persons are equally entitled to freedom of conscience and the right to freely profess, practice, or propagate religion. This means this right is also available to citizens and foreigners. Okay? So this is Article 25, Clause 1. This is Article 25, Clause 1. Okay? Now, next. Article 25, Clause 2. Article 25, Clause 2. Nothing in this article shall affect the operation of existing law or prevent the state from making any law, and we'll get to the details. Nothing in this article shall prevent the state or shall affect the operation of existing law or prevent the state from making any law. A. Regulating or restricting any economic, financial, political, or secular activity which may be associated with religious practice, which means the government can make a law regulating the practice of religion. For example, witchcraft, human sacrifice, animal sacrifice. The government can stop this, right? Understood this? Okay. B. Providing for social welfare or reform or throwing open, and this is very interesting, providing for social welfare and reform or the throwing open of the Hindu religious institutions of a public character to all classes and sections of Hindus. Basically saying lower castes cannot be stopped from entering any religious institution. This is a beautifully crafted article giving into form societal realities. So when you hear of Dalits not being allowed to enter temples, or when you say a priest, when you restrict Dalits from becoming priests, it is a direct violation of 25 2b. Okay, understood? So these are your basic provisions. Now, this becomes slightly more interesting because over the world there are several developments that have happened. Like for example, when we speak of Islamic women, say let us say this. Okay, okay. The burqa is the whole from head to toe, and what covers the face is called hijab. Okay. Now France had banned the burqa for national security reasons, not the hijab per se in the original form, because it was a national security concern. In India, we take a softer approach to costumes and accessories of religion. So for example, in India, you will never be stopped at the airport because you're wearing a burqa. You will not be stopped at, you will not be allowed to, it will never be the case that you will not be allowed to board a train or any of those things. Okay. Now, any political activity basically meaning using religion for congregations against the state, or making a religion based political party. If you want, you can make a law on banning religion based communally sensitive political parties. Now, for example, you have a few political parties which are which have very strong belief systems in Islam, but they can never say that if you're not an Islamic person, you cannot join this political party. That can't be the case. Okay. Let us say we talk about Owaisi's party. If you are not a Muslim, you are still allowed to join Owaisi's party. That's something you must understand. Okay, all right. Now, 25(2)(a) and B. Now, there are two explanations which were dedicatedly given in the constitution. For example, in the faith of Sikhism, people who wear kripan in Sikhism, a few people who जिसको कहते हैं अमृत चख लिया, then they carry a small pointed dagger like accessory, a dagger like object with themselves. Now this is pointed, and pointed sharp objects are not allowed on aircrafts, but if you are somebody who's carrying it for religious reasons, that is also okay, right? So the wearing and the carrying of kripans shall be included in the profession of the Sikh religion. Similarly, for example, if you are somebody who's a Sikh who wears a turban, now if you go and join the army, the NDA or the IMA, where all cadets have to necessarily, get their hair cut very small and they can't keep a beard. Even if you go to the police academy, you can't keep a long beard, you can't keep long hair. But if you're a Sikh, nobody's going to say anything to you. You are religiously allowed to do this. Okay, so this is your explanation 1. This is your explanation 2. Now, this is where a lot of this is understood. That when we say Hindus, it includes all the Indic religions such as Sikhs, Jains, Buddhists, and therefore your understanding of these institutions will also be construed accordingly. Which is why I said SC and STs are often considered to be Indic to your Hindu religions per se. So this is what is called Article 25. Now, Articles 26, 27 and 28 are very easy. After this, I'll of course get into Uniform Civil Code and some of the issues that have been going on, and I'll give you a brief idea about what those issues are. So, 26, the freedom to manage religious affairs. See, subject to public order, morality and health. See, the reasonable restrictions are more or less the same. Subject to public order, morality and health. Article 25 has public order, morality, health and all other fundamental rights. Here it is only public order, morality and health. It does not mention all other fundamental rights. Every religious denomination or any section will have the right to basically setting up religious institutions. To set up and establish and maintain institutions of religious and charitable purposes. Let me just put it together. Sorry. Yes. To manage its own affairs in matters of religion, to acquire property, and to of course administer such property in accordance with the law. You can make a law, and only under this law can you exist as a religious institution. So if the government makes a law that says your religious institution, whatever it in nature it might be, has to pay taxes, or has to pay a certain amount, or has to do X number of things, then that law will of course take primacy. So rule of law, the government will make a law and go about it. Like for example, in the Sabrimala case, there is actually a law that allowed the administration of the temple to disallow women from entering the Sabrimala temple. And that is why the Supreme Court had struck down that law and therefore allowed for the entry of women of the menstruating age group to the Sabrimala temple, right? And this is also an ongoing debate, largely originating from South India, that temples and administration of temples should entirely be left to the leaders of different religious faiths, and it should not be left only and only to the government. Like for example, today there is a law that the government has a role to play in how the Shedi Trust, the Sai Baba Trust, the Tirupati Trust, the Vaishno Devi Trust, how all of them operate. And that is usually how it is done. Okay, so you have the freedom to have your own ecosystems. ठीक है? All right. Okay. Now, Article 27. यही सारा प्रॉब्लम यहाँ पे है. ठीक है? Article 27. Freedom as to the payment of taxes for promotion of any particular religion. What does this mean? It means no person, which means citizens or foreigners, shall be compelled to pay any tax, the proceeds of which are specifically appropriated for the payment of expenses for the promotion or maintenance of any religion or religious denomination. इसका मतलब either you are contributing to a religious institution or the religious institution within themselves. Okay? And this is all recognized and regulated by the law. ऐसे हवा में exemption नहीं मिलता है. You have to register as a charitable organization. You have to be registered as a trust or a society. ऐसे हवा में नहीं कर सकते कि मेरे को पैसा दे दो और टैक्स मत देना. ऐसा नहीं होगा. You have to be registered as a charitable institution, a trust or a society, and then once you have that certification, this is basically exemption from taxes. This is very similar to NGOs. NGOs have to be registered as trusts and societies. So NGOs don't pay taxes. NGOs don't pay taxes. If you donate to the NGO and the NGO has an income tax exemption certificate, then your donation to the NGO gets exempted from your taxes. Right? That is important. Anyways, so no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in the payment of expenses. So let us say, for example, there is somebody who works in an ashram. Let's say there is somebody who works, there must be somebody who will be handling accounts of Sadhguru, right? There will be somebody who will be in charge of the donations Sadhguru's foundation is getting and how the donations are to be spent in what order and all of that. There will be an accountant, there will be a finance officer, there will be a human resources officer. What about those people, right? Here, those people are not included. Those people are working for an organization. The work that they are doing has nothing to do with the promotion of religion. That's an administration part of it. I know this is too technical and you can choose to forget it after 5 minutes, but all that I'm explaining to you is religious institutions do not pay taxes. Ramdev doesn't pay taxes. Patanjali, which is a registered private company, that definitely pays taxes. Sadhguru doesn't pay taxes. Your Art of Living Foundation doesn't pay taxes. You would remember that Nirmal Baba person who's in jail, he didn't pay taxes. Your Messenger of God person who also ended up making movies also and starring in the movies also doesn't pay taxes, right? And he's also in jail. And there was a point of time where these and they used to popularly be called godmen. This Radhe Ma person, right? She also never paid taxes. Okay. Anyways, so that's Article 27. Now let's look at Article 28, which seems to be slightly complicated, but it actually is not. Freedom as to the attendance at religious instruction or religious worship in certain educational institutions. Article 28, Clause 1. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. You may remember I have discussed this in a broad amount of detail when we were doing I think governance. Anyways, what does this say? What does this complicated article say? Religion cannot be taught or cannot be instructed at any educational institution wholly maintained out of state fund. At any educational institution wholly maintained out of state funds. ठीक है, मतलब any sarkari school, there have been then several Supreme Court judgments where this also includes national curriculum and so on and so forth. But sarkari school, जैसे केंद्रीय विद्यालय, नवोदय विद्यालय, central schools, Anganwadis, a lot of these, they are considered as government educational institutions. Now please understand this. What does religious instruction means? It means education and some form of compulsory religious practice. This religious instruction means education and religious practice as well. Now there are some practical explanations to this. The first is, and please understand this, the first is, if you don't want to participate in a school prayer, and you are, let us say you are in a government school and you don't want to participate in a school prayer which asks you to, say the prayer is in the praise of a Hindu god, you can choose to say, I'm not going to sing that prayer. Nobody is going to say anything to you. So that's number one. Two, if you are not questioning people on religion, that is fine. So when CBSE curriculum has Ramayana or Mahabharata, you are not questioning people on Hinduism or Sanatan Dharma. Ramayana and Mahabharata was taught as a part of the Hindi curriculum, as a part of moral philosophy, where you were basically asked to understand what are the moral value lessons that you have learnt. Okay, what are the moral value lessons that you have earned. NGO employees pay taxes. Yes. Now, nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under an endowment or a trust that requires religious instruction and that shall be imparted in an institution. मतलब कॉन्वेंट स्कूल है, सरकार चला रही है, एक ट्रस्ट. नाउ लॉट ऑफ टाइम्स यू हैव पब्लिक प्राइवेट पार्टनरशिप्स इन स्कूलिंग. एक्चुअली ऐसा होता है. समटाइम्स द लैंड इज गिवन बाय द गवर्नमेंट, the building is constructed by the private, or the land is by the private, the building is constructed by the government. These kind of models have been existing in school systems in India for a very, very long time, ever since time immemorial. Okay, anyway, so basically what it says is that if the institution is established under a religious trust which requires कि भाई हमने कॉन्वेंट बनाया तो भाई बाइबल तो पढ़ाएंगे, अच्छा लगे बुरा लगे, we'll praise the Lord, so we have to praise the Lord. Even if that convent is CBSE, doesn't matter. Even if that convent is ICSC or state board, doesn't matter. Even if the convent school is being regulated, is being administered by the state, it doesn't matter. It is being set up by a trust. So that is what is meant. Now, 29th clause 3. No person attending any education institution recognized by the state or receiving aid out of state funds shall be required to take part at any religious instruction that may be imparted in such institutions, or to attend any religious worship that may be conducted in such institutions or any premises attached thereto, unless if the person is a minor and the guardian has given their consent. Interesting. No person attending any educational institution recognized by the state. This means schools, colleges of any board, whether center or the state, doesn't matter. If you are a recognized school or college, or you being paid money, the government is giving you, it's a state funded school or a college, you cannot be compelled, you cannot be forced to participate in any religious instruction. Later on, there was a Supreme Court judgment. There was a Supreme Court judgment called the TMA Pi Foundation case. The TMA Pi case, not relevant for the exam. This TMA Pi case basically had a tremendous effect to Article 28, Clause 2, wherein it said that if the state is funding an institution, if the state is funding an institution which was under a religious trust, then if it is fully funding it, then the state can intervene on administrative and welfare grounds. And if the state is if the institution is partially funded, if the institution is partially funded, right, in such a scenario, you can only interfere on administrative grounds. So that is something that we must understand and we must get right. Okay. This is why, for example, Stephens, which is part of DU, which is a fully funded central university, is a religious minority institution. The Supreme Court, through this judgment, allows Stephens to retain its character, which is in an institution to provide high quality learning to the Christian community, wherein 50% of the students are Christians, and then the remainder 50% are non-Christians, because that's the identity of it. And Stephens, being a minority institution, says, I have some special powers, which is that I will take the DU cutoff as the admission criteria, but I will also like no, no, Bhivan, send me the certificate, I can guarantee you that's not the case. Okay. Anyways, so where were we, right now? So Bhivan, what happens is there is something called SC, ST Hills and ST Allied. These are subquotas in the ST community. In that rare scenario, depending on state government and union government guidelines, that can happen. But in most cases, that's not the case. Anyways, so yeah. So Stephens therefore says, I'm going to take DU cutoff as my criteria, but I'm also going to have an interview of the students before I give them final admission to undergraduate courses. ठीक है. So ये है आर्टिकल 28. अब इसके एप्लीकेशंस में सिर्फ एक ही इशू है, यूनिफॉर्म सिविल कोड, जो एग्जाम के लिए रेलेवेंट है. बाकी सब सबरीमाला, संथार, बाबरी मस्जिद, ये सब एग्जाम के लिए कुछ भी रेलेवेंट नहीं. आई विल स्टिल गिव यू द ट्रिपल तलाक इशू, पर्सनल लॉज, ये अभी हम पढ़ेंगे. यू कैन टेक अ 5-minute break and then we will cover the applications of 25 to 28. All right. It is often discussed that religious institutions should pay tax, but because religion is often considered as a mechanism of reform movement, that is why. Shahbaz, what about those who are fully maintained by private individuals? Can the person reject or not to reject? Yes, they can. Because it's a part of the right to conscience. That would be illegal because destruction of public property is not allowed, or any tarnishing of public property is not allowed. Okay. Now let's spend some time on understanding the broad provisions or the broad explanations of the Uniform Civil Code. Why are we referring to it? Why is this important? You see, the first question that we have is the source of law. The first question that we have is the source of law. When you are making a law about something, about anything, what makes you make a law about it? This is very similar to the determinants of morality, right? Where your society, your culture, your family, all of these have an impact on what are the moral standards as far as law is concerned, or as far as morality is concerned. One of the primary sources of law happens to be religion. And if you look at broad religious text, it usually affects marriage, property, and adoption. Okay. So India has to make laws regulating all of these. But India has to make laws making all of these, and these are called personal laws. You have to make separate personal laws for separate religions based on what their religious text says about it, and you have to make sure that only the reasonable, the fair, the just provisions of religion are accepted and given legal status. All religious dictats or all religious commitments are not legally recognized. Some are legally recognized. They are in the form of personal laws. Now, these personal laws have had several issues, such as they are sometimes discriminatory, sometimes they are regressive, sometimes they're biased on gender, sometimes they are very conservative, and so on and so forth. And because we live in a rule of law country, the law can always supersede religion to be an instrument of morality. Okay, right? Now, once we understand this, then we will understand everything else. Okay, then we will understand everything else. Chaliye. Now let's get into Uniform Civil Code. क्या है, क्यों है, क्या प्रॉब्लम है? See, recently, the Supreme Court has admitted a PIL. That PIL requests the Supreme Court or prays to the Supreme Court for making gender neutral and religion neutral personal laws. that your laws should be based on, uh, uh, you know, uh, what is right and wrong, and more specifically with respect to property, wherein you look at succession of property and you look at the inheritance of property. So this is why this is brought back into debate. Now let's understand. Abhi kya hai? You have for Hindus, for Muslims, for Christians, and this Hindus includes Jains, Buddhists, and Sikhs, which itself is a very flawed idea because they have very different religions and different practices. You have separate laws for religion and property. So you've got the Hindu Marriage Act, you've got the Hindu Succession Act. Similarly, you have the Muslim Marriage Act, you have the Muslim Succession Act, you have the Christian Marriage Act, right? Now, if it is an inter-religion or an inter-caste marriage, then you have the Special Marriages Act, which is applicable. We have a plethora of these laws, and each of these have had some or the other issues. For example, very recently when we were looking at raising the age from 18 to 21, it had implications on marriage laws, because Muslim Marriage Act basically said any girl who attains the age of puberty should be allowed to get married. But now we have a dedicated law for it called the Prevention of Child Marriage Act. That is how you could just make a single change and it would override all the other personal laws. It was until 2000s, I think 2005 or something. It was in 2005 that we made a change to the Hindu Succession Act, which gave Hindu daughters an equal share in the property. Okay, before that, Hindu daughters did not have an equal share. But if you're talking about marriage, then we're definitely talking about divorce also. Yes, so marriage includes marriage plus divorce. Okay, now let's understand the need of it. What is it that we are referring to? See, the Uniform Civil Code basically is like the code of labor, where you have merged multiple laws into a single law. It does not mean that one law will be applicable to all religions. No. If it, let's say, has 1 to 100 sections, say 25 sections for Hindus, 25 sections for, let's say, 25 sections for Buddhists, 25 for Jains, 25 for Sikhs, 25 for Muslims, 25 for Christians, another 25 for interreligion. So 100 and 175 sections. So all of these will be in one law instead of all other laws. That is the first understanding that you need to have. And when we make this one law, we are expected to remove all the discrepancies and the bad things about all existing personal laws. So Uniform Civil Code, the idea of it is called a single law which will be applicable to all citizens of India, and this will cover marriage, divorce, inheritance, succession, adoption. And this marriage, divorce, succession, adoption, all of these are concurrent list subjects, which means the states can also make a law on this, but if the center wants, the center can make a law and that will override the states. That is why you may have heard that currently Goa has a uniform civil code. So the Hindu Marriage Act does not apply to Goa. The Uniform Civil Code, which is only for Goa, applies to Goa. Okay. Now, why has there been a demand? Why has there been a need? What is the basic issue? The often we say this, and it's we say that from Shah Banu to Shaira Banu, right? That's often we I wanted to show you something. One second. Uh, There's a beautiful book I was reading on marriage, divorce, and law in India. When you want to find a book, you can never find the book. Might be in the other room. Anyways, I'll show that book to you tomorrow. So, the origin or the demand of the Uniform Civil Code starts from the Shah Banu case of 1985, wherein Shah Banu was married to, she's a Muslim, she was married to another Muslim person, and they don't have the concept of alimony. What they had is a concept of meher. Meher is an amount which is decided at the time of the Muslim wedding, which is called nikah, and this is the amount which is set aside and promised to the wife in case there is anything wrong that goes with the marriage. She had to be divorced from her husband, but the meher amount, which is often considered a formality, in this case became an issue and was considered a very, very less amount. So she went to the court challenging this, and the court said, and the court increased the meher amount and also said this is why we need uniform civil code in the country. Interestingly, the directive principles of state policy under Article 44 also encourage the state to have a uniform civil code. The most recent implementation has, in a landmark manner, has been a policy, a religious policy intervention, has been the case of Shaira Banu, wherein triple talaq was declared unconstitutional. The Supreme Court directed the Parliament to also make it a criminal offence. The Parliament first passed an ordinance and then made a law making triple talaq a criminal offence. The law is called the Protection of Muslim Women Marriages Act, and so on and so forth. Okay. Now, why do you need to make a law like this? What are the general discussions around it? See, apart from this, when you look at several religious-based issues, say the Sabrimala case, the Indian Young Lawyers Association versus Union of India, which is popularly called the Sabrimala case. It is a very specific issue with a specific problem of a specific religious practice. Here you are trying to solve an issue of an entire religion altogether. So these are what we called religious policy judgments. This is not a religious policy judgment, okay? Because this has a very limited scope in the larger context to it. It is about a temple and about a specific issue in that temple. Now, when we do talk about the Uniform Civil Code, we must understand primarily that there is a set of reasons why we think it makes sense or why it should be done. The primary need for uniform civil code arises from vulnerable sections of society, primarily women and religious minorities. I'll give you a simple example. Under the Hindu Marriage Act, if a couple is not physically intimate, those are grounds for marriage, right? Now, most of the marriages in India often happen to be arranged in nature, and as a result of which, the couple get married. It's practically, you know, your life to be spent with somebody you have no idea about. Now, in that case, there could be a consent issue with respect to intimacy. And given how divorces are often stigmatized in India, either a person, let us say, either a person compromises their consent and could be an issue of marital rape, but saves the marriage, or the woman doesn't compromise her consent, could lead to a divorce and get stigmatized in society. So that is of course one of the interpretations of how it affects vulnerable sections, particularly women and religious minorities. Second, the religious laws in India are extremely complex. They are not suitable for the average person to understand, imbibe, and marriage and property affect almost everybody in the country. Third, somewhere when we see gendered justice as a larger concept, in Uniform Civil Code, we are trying to essentially promote and uphold gender justice. For example, right now, in all states except Goa, a Muslim man can have more than one wife. Now, of course, Islamic jurisprudence says that all the wives will be taken care of and all of those things. Firstly, taking care of a wife is itself a regressive notion, but let us say that is the case. It still could have certain repercussions on day-to-day activities, right? Uh, it is often understood that when you treat religions fairly, it's not that you're being anti-secular, you're just being morally and reasonably secular, right? And once you do that, then the scope of religious-based vote bank politics may also reduce. The basic challenges to Uniform Civil Code are that first, if I have the right to have my religion and practice it in any way I want to, that's under Article 25. You can't force a bunch of laws just because you want to regulate it. Two, this is ultimately a personal matter. How a person wants to transfer their property and how they want to get married and not married, and if they want to take the support of religion, then they should not be stopped from it. They should not be prevented from it. Third, communal politics. See, the demand for or against uniform civil code today has now become a political issue, that it is about the state encroaching religion and so on and so forth. And given how diverse India is, given how sensitively diverse India is, this therefore becomes an even larger issue to deal with. Apart from this, if any political party really wants to do this, they're going to risk losing some religious vote bank or the other. And that is a very significant vote bank for the people who want to come to power. Now, even the Law Commission says that we must have a codification of all personal laws and a singular codification of it. And second, when you are trying to do this, you should try to make sure that the people who are drafting this should be as diversely constituted, a dedicated special commission, public engagement, public participation, all of that must be taken care of. And third, while it seems like the government seems to be pushing this agenda or seems to be responsible, but if we could somehow convince and take into confidence the leaders of socio-religious groups in India, and if they start saying that a uniform civil code is in your best interest and is not going to take anything away from you, it is a very good way to essentially look at religion and the promotion of religious-based issues, right? Through these principles on religion, the Supreme Court also has come up with something called the doctrine of essentiality, which means that if this practice is not essential to your religion and is more harmful than it is beneficial, then we can look at removing this practice. That was essentially the principle on which the Supreme Court decided to declare triple talaq as unconstitutional, right? So these are the things that we must know. These are the things that we must understand. Okay, all right. Thank you. We are done with 25 to 28. We'll cover 29 and 30 and basic structure and harmonious construction tomorrow. It's going to be a very interesting class, and I hope to see you tomorrow. And then we'll move with Parliament from day after. President and Governor, and then Parliament from day after. Chaliye. Thank you.